Hey everybody, how's it going? Welcome back to Copper Jacket TV. So we finally got an update from the Supreme Court in Snope v. Brown and Ocean State Tactical v. Rhode Island. These are two extremely important cases that challenge both the so-called assault weapons bans and magazine capacity limitations, or mag bans. So let's talk about what just happened today. Hey, real quick, a vast majority of the people that are watching these videos are not actually subscribed to the channel. If you support the Second Amendment and you support what we're doing here, trying to spread information out to the people, consider hitting that subscribe button. It's free, it only takes a second, but it really does help us out here quite a bit. Thumbs ups are always appreciated, and the comment section is where everything's going on. So with that being said, thank you to everybody for your support. Okay, so let's go ahead and talk about what's going on here. Now, just to catch up real quick, Ocean State Tactical v. Rhode Island is the case that is challenging the mag bans, okay? So your magazine capacity restrictions and limitations that say that you can't have more than 10 rounds. Snope v. Brown is a case that is challenging the so-called quote-unquote assault weapon bans out of the state of Maryland. Now, both of these cases have a really weird history at the Supreme Court. They were both petitioned to the Supreme Court back in August of 24. They each got their first conference in December of 24. Conference is basically where all the Supreme Court justices get together and determine what cases they're going to take, what cases they're going to deny, and basically what they're going to do with the cases that were conferenced for that day. Now, following that December conference, instead of denying it, accepting it, or moving it on to the next conference, they decided to, well, simply just reschedule them. And so we had to wait to see what was going to happen after that. Then all of a sudden, both cases reappeared for a January 10th conference. Following that January 10th conference, we had two more conference dates set for each one. That basically means that they were moved off to the next week for the Supreme Court to, reconsider again what they're going to do with these cases. So these have been scheduled since back in December of 24. Now, after this last one back on January 24th, that was it. So we were waiting. January 24th, they had a scheduled conference date for both of these cases, and we were waiting to see whether or not they would accept them. If they accepted them on that day, that means that they would probably be heard and decided this year, which would be phenomenal, right? But instead of finding out what the Supreme Court was going to do with them, we didn't find out anything. There was no updates whatsoever. They didn't reschedule it. They didn't set it for a new conference date. The website for it, for the Supreme Court, just basically was left as is. It said conference date January 24th of 2025. And there was no update from that. Well, I have been refreshing that website pretty much 6 times every single day. We finally got an update. Now, there's good news and bad news, and we'll start off with the good news first. Obviously, it's good news that they did not deny either of those two cases. So that is good news because it means we still have a shot for them to take at least one of these cases up. Hopefully both, but more than likely if they were to take one, it would probably be Snope. Either way, it's good news that they didn't deny either case. Now, after refreshing the website for the 1 millionth time finally today, we got an update, and that is that both of these cases have now been rescheduled for conference on February 21st. So next Friday, both of these cases are going to be reconferenced. Now, the bad news is they could still deny both of these cases. It doesn't give me much hope knowing that both of these cases were kind of sitting in limbo for the past few weeks. That could be the amount of time that was needed to write a dissent. So Justice Thomas could write the dissent in this, saying that he would have accepted these cases, and obviously that could be a very long dissent, and so we could still see a denial. And the other bad thing is actually part of good news, but the other bad thing is now, because it's taken so long for them to consider what they're going to do with these cases, even if they decide to take one, which would more than likely be Snope, it's going to push it into 2026. So we wouldn't know anything or get any type of relief until at least 2026, which, would be a problem. I mean, people are still living under these laws, for this entire time. So even if they decide to take it, it could be quite a while before, anybody actually gets any type of real decision that could change the laws in this country. Now, I try and look at things through an optimistic lens to see if there's any glimmer of hope that we could have success in any of these two cases. And to be honest with you, I'm not really convinced about Ocean State Tactical, but I do have a better feeling about Snope v. Brown. Again, this is just based on my gut feeling and my own personal opinion. But Snope v. Brown, the way that it was handled at the circuit court level, at the appellate court, was so egregious and so abhorrent that I don't see any way that the Supreme Court doesn't try and fix that. Because basically the appellate court said that they're not protected by the Second Amendment because they're too similar to military style weapons. And so because they're so similar, they're not even constitutionally protected under the Second Amendment, which is absolutely, like I said, it's just absurd. If you just take a look at the definition of arms, anything that you can carry in your hands or wear on your body to strike at another in wrath could be considered an arm. It doesn't have to be militaristic or not. It's protected by the Constitution, plain and simple. But what the circuit court did was so bad that the Supreme Court simply has to fix this. If they don't fix it, I completely lose faith in the Supreme Court and their ability to make sound decisions whatsoever. This case has to make it up to the Supreme Court. It is absolutely perfect for them to take. There is nothing that is better than Snope v. Brown at the Supreme Court, at least right now. So again, I'm trying to remain hopeful with Snope. I don't think anything's going to happen with Ocean State, but again, that's just my opinion. But at least now we have a conference date. While we were sitting in limbo for the past 3 weeks, we can finally say this is when they're going to decide what they're going to do with it. Or they might decide to reschedule it. I mean, take a look at Bruin. It was rescheduled 6 times before they finally decided to take it up. So it's not unheard of for these things to be, bounced or kicked down the road until they're finally accepted. So again, I'm trying to remain hopeful here, but I wanted to share with you that update here that we finally have a conference date set for February 21st, and hopefully they take both. We'll see what happens. So I wanted to let you guys know about that. I want to thank you all very much for watching. Please like, subscribe. You guys have a great day.